It's Tan Talk.
It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday evening at 5 o'clock, and we are here live on the radio on FLA Law on the radio. I am Matthew Noyes. I'm one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, the oldest personal injury law firm in Tampa Bay. We have been helping people that have been hurt by the fault of others since 1955. And so we thought it was just good to also give back to the community by producing this show every week to really be available to answer questions that you may have. As you heard, I do personal injury law. That means car accidents, trip and falls, also workers' compensation and Social Security disability. So if you have questions regarding those areas of law, you can call us. We are live on the radio at 441-3000, and I'm happy to tackle those questions. But I am also blessed to have my friend and my colleague, Tony Damanakis, here as well. Tony, thank you for taking some time out to give back to the community as well.
Thank you, Matt. It's a pleasure to be here.
Sure. Tony, why don't you let our listener know what areas of law that you specialize in and how you can be available to help them in the next hour.
Thanks. So I'm a member of the law firm Peacock, Gaffney, and Damanakis. We're located on Sunset Point Road in Clearwater.
Very close to our office, yes. Right around the corner.
Right around the corner. I've been practicing for 30 years. My practice consists of real estate, business matters, litigation, probate. My partner does family law, and
Mr. Gaffney was a guest on one of my shows just a few weeks ago, so it was really good to have him on here too.
So he's been at it for 40 years, yes. And it's just it's a great honor to practice law, despite all the lawyer jokes, which I don't mind. So if anyone has a call-in lawyer joke, we'll take it.
It has to be a good one, though.
Yeah. PG.
That's right. Yeah. So if you have questions for Tony, you can give us a call on the law line at 441-3000. In addition to being live on the radio, we are also live streaming the show on the firm's Facebook page. And the firm is Perenich, Caulfield, Avril Noyes Injury Lawyers. And you can see us live on the radio. And if you don't want to hear your voice on the radio, you can just type in your question right in the comments, and Tony and I can tackle your questions there. And we are also live on the YouTube channel under Perenich, Caulfield, Avril Noyes as well. So we are here for you and all ways to be available to answer your questions. So if you have a question, please don't hesitate to contact us. You have two lawyers here ready to give you some answers to questions that you may have. But Tony, before we take questions, you do a lot of probate and estate planning and such like that. What are the common mistakes that people make when they're creating their estate plans?
Interesting you should ask. I noticed today in USA Today, there was an article about common misunderstandings regarding probate process.
They knew you were going to be live on the radio.
It seems to be a timely question you ask.
Sure.
I'll give a general overview for folks who may not know what is meant by probate. Basically, when we die, we may have some assets in our possession. That could be bank accounts, checking, savings, stocks. Could be a house, could be a car, could be any number of things. If they're not jointly held with a spouse, they need to be transferred somehow. Now, if you hold it with a husband and wife, they will transfer automatically as long as they're titled that way. So if you're both on the house will go to the surviving spouse. If you're both on a car, bank account, etc.
It has to be and or does that matter?
It should indicate either husband and wife or tenants by the entirety or some kind of joint spousal relationship.
Okay.
So wording is important.
Yes.
So be careful, especially when it comes to real estate. So assuming there's an asset, let's say you passed away and you had this old stock that you bought in college, never put it in your wife's name as well. It needs to transfer. And there's a couple ways you can transfer an asset when you die. One is through a will. which is a document that says when I die, I want my things to go this way and to these people, and I want this person to be responsible to do it. That person who is responsible is called a personal representative.
Okay.
Up north, they're called executor or executrix if it's a lady. And they will be responsible to process the will, which means it gets filed after you die. It's a public document. And they have to go through the process of getting it approved by the court. You get authorized to be the personal rep, and then you can do what you have to do. You can take your order down to the court, say, I'm the personal rep. You can close out the bank account and do what it is the will said you should do.
And the creator of the will gets to pick who the personal representative is.
Absolutely.
Okay.
So
that's one of the benefits of having an estate plan, including a will.
It's very important, especially for young families, for example. They might say, well, if something happened to us, it'll go automatically to my kids. Well, that's partially true, but what if your kids are under the age of 18?
Right.
Who's going to manage those funds for them until they become 18? Do you really want your kids at 18 years old getting a bucket full of money?
Right.
These are things that you can all plan for in a will as a young family.
Okay.
Older families and older parents, they can account for maybe spouses who are spendthrifts, who are maybe struggling with certain addictions, alcohol or drugs or depression. They can be assured that in following their passing, these things will be taken care of in a responsible fashion. You mentioned having a will. It's important. What happens if you don't have a will? That's called intestate, intestate.
Yes.
Not the end of the world, but not the greatest scenario.
What happens? What happens if someone dies and they don't have a will?
So the state will say who gets what.
Okay.
Now,
I think that common misperception is that the state gets everything.
Right.
And that's not the case.
Totally not the case.
Okay.
It is a very rare circumstance where the state will get anything in intestate circumstances. What the state does is set forth in the statute basically a family tree. And it says if you don't have a will, things go to your wife. If you don't have a wife, it goes to your kids. If you don't have kids, it'll go to your siblings. If you don't have siblings, it'll go to your parents, etc., all the way down the genetic family tree. You can imagine that it's very difficult for someone to go all the way down that genealogical process to have no one.
Right.
Only in those very rare circumstances will the state get anything from you.
Okay. So that's one of the misperceptions is that if you die without a will, then the state gets everything.
Correct.
That's a misperception. But I hear this a lot, and I think it's a misperception as well, and I hope you can clarify it for me. A lot of people say, I have a will so I can avoid probate. Just having a will doesn't avoid probate, right?
The will actually is the document that creates probate.
Right.
You cannot avoid probate with a will. You can avoid probate with other tools and techniques. The most commonly referred to is a revocable trust.
Okay.
You create this trust and you think of it as if it were a box. And then you can put your stuff in the box. You can put your checking account, your stocks. You can put your house. I don't recommend, we don't advise that you put an automobile in the box because that creates a potential liability, which you can speak to about car accidents, underinsured situations, etc. But everything else can go in the box. That's the trust. You appoint yourself while you're alive to be the trustee, the person in charge of the box. You then in the trust say, well, if I die, I want a successor trustee, the backup.
Okay.
That backup will take over the box and be responsible to do exactly what you say should be done with the things that are in it. That avoids probate. That's private. No one gets to see that document except the beneficiaries of the trust.
So people do get to see the will?
The will is public.
Okay.
It has to be filed 10 days after your passing. And
anybody can go to the courthouse and look at the will to see what assets you have and who your beneficiaries are and such like that.
Sometimes family laundry can be aired that way, and you may or may not want that to happen.
All
So
right.
trusts are a good way to avoid probate.
Now, if you own a trust, do you still have control over the assets while you're alive?
You have complete control.
Okay.
You make yourself the trustee during your life. You'll be able to sell, spend, lease, borrow, just like you would in your individual capacity.
Okay.
So there's no difference.
Oh, that's interesting. So why would somebody choose a will over a trust or a trust over a will?
So the basic reason is a trust is more expensive to create now. It's it's a 26 to 28 page document and more complicated from a point of view of preparing it. Then you have to put things in it. So if there's a house, there needs to be a deed that needs to be transferred. So it's a little more expensive up front, whereas a will is relatively inexpensive up front. So some people say to me, well, why should I spend more money on a trust when I'll let the kids worry about it? And that's their philosophy.
Right.
Others say, no, I don't want I want to save money to the estate and minimize probate. So what does probate cost? Probate, under the statutes in Florida, can cost you up to 3% of the value of your estate.
Wow. Okay. So if you
let-
have a house in the estate and such like that,
Yeah, a common house in Florida now can go for 150 to 250.
easy.
3% of that is a sizable fee. You're talking about $6,000 to $8,000 in probate costs. Again, some people say, "Well, I'm dead. Who cares?"
Yeah.
And some people say, "Why should the kids pay that money? Right?
Right.
I'd rather give it to a charity or to my kids."
Or the kids.
So you can spend a little more upfront on the trust to avoid probate costs, thousands of dollars in probate costs, or you can not worry about it, minimize your upfront cost. That's good flexibility. There are other ways that, depending on the circumstance, depending on the complexity, that you can avoid probate as well.
Now, is the trust more beneficial that if you have a family member who may be a minor or somebody that may have the inability to control money, is a trust a better way to protect that beneficiary and the assets that they receive?
It's essentially the only way, because even if you had a will and you wanted to protect them that way, you would have to essentially create what's called a testamentary trust.
So it still ends up being a trust.
It pops out of your probate. Able children can be cared for. So you can create a trust out of your will, or you can create the trust right up front. But yeah, to answer your question, if you're going to require some care and planning over a long period of time, you're going to need a trust.
That's what it sounds like.
Yeah. It's very common for persons with disabilities.
No, I think the trust is probably the best way to go, because it's also private as opposed to being public. And it sounds like you have more control over how the assets are handled once you pass away.
And the other thing to keep in mind with a revocable trust is exactly that: revocable and amendable. So you can change that just like you can change a will.
Okay. What is it required to change or to revoke the trust?
So the trust, you would execute the amendment the same way you executed the original. You do it in the presence of two witnesses and a notary, and those witnesses are asked questions that make sure that you understand you are who you are. You present ID. You understand what you're signing, and no one's forcing you to do it against your own free will. Those legal questions and ritual, if you will, give it legal binding. It makes it very difficult for anyone to challenge a will or a trust if they go through the proper process.
And that's why it's so important to talk to an attorney who understands the process that needs to go through.
Yeah.
So call listeners, if you have questions regarding wills or trusts or the probate process, Tony's your guy. He's here till 6:00. Give us a call at 441-3000, and we can tackle the question that you may have. You may be thinking about, you just don't want to spend the money to call the attorney, or it's just one question and you don't want to bother the attorney. That's what we're here for this evening and every Tuesday evening, is to be available to answer the questions that you may have that may be bothering you, or or concerning you or a family member. So give us a call, 441-3000. Tony, we were talking about the probate process in Florida. Can you give us an idea of what happens during that process and about how long it takes?
Sure. So the first thing that's done is, like we indicated earlier, you record the will with the court. Then you actually file what's called a petition. And depending on the complexity of the estate, it can be a petition for summary administration, which pertain to estates $75,000 or less,
Okay.
or someone who's passed away 2 years ago. If it's more than $75,000, it is a formal administration. So summary is pretty quick. And here in Pinellas County, we have a great judge and a great court system, a wonderful clerk, and wonderful court workers who really do a wonderful job processing things.
Great.
You can get a summary done in about 45 to 60 days.
Wow, that's
from
amazing.
filing.
That's
They're
amazing.
really commendable.
In the personal injury world, you can't do anything within 45 or 60 days in litigation.
The summary, again, is essentially, think of it as a shortcut where assets are limited to up to 75. And you'll basically say, if there was a will, who gets it? If there was no will, who gets it under the intestate statute? And the court will issue an order saying, okay, A, B, and C get it per the will, finished. So you go down to the bank and say, here's my order of summary administration.
What about creditors, though?
So in the credit, you have an obligation. Whoever files that petition.
The petition for a personal representative?
Yeah, whether
Okay.
it's a summary or whether it's a formal, they have an obligation to disclose in that petition that there are no creditors, or there are creditors and we've taken care of them.
Okay, and how did they take care of creditors?
So you literally check, you get a hold of the mail. You determine, is there a credit card? Are there medical bills unpaid? Were there any lawsuits that can appear to be an issue? Are there any old tax issues with the IRS? You have some due diligence to do. It's
Okay.
not just, oh, I didn't know about that.
That's not poof.
Yeah. In theory, if you purposefully neglect or ignore or hide any knowledge of creditors, and you don't give them notice, and you don't take care of them, you could actually have personal liability on the back end.
Oh, wow.
So
Not
it's
just the estate. You as the personal representative can have liability.
if there's wrongdoing shown.
Wow.
Very
Okay.
unusual, but you got to be honest and transparent with the creditors. If there are 75 creditors and $3 million owed, and there's only $50,000 in the estate, there's a priority checklist. Priorities are for funeral and probate costs. Reimbursements there first,
Okay.
and then the creditors are going to have to take, obviously, a great reduction on what they're owed so that they're all satisfied. They all get a very small piece in that extreme example.
Yeah. What happens, or what can the personal representative do to protect the estate from a creditor popping up 2 years from now that they didn't know anything about, but all of a sudden, hey, there's this bill that's due, or this hospital bill that's due that's now owed. What can a personal representative do to protect the estate from that happening?
So a personal rep should always be mindful of whether or not a claim from a creditor is legitimate. And in the probate process, they have an option to object to the claim. It doesn't necessarily mean that it won't get paid or it's not valid, but it does force the creditor to surface with proof of the debt to demonstrate the documentation of why this is a legitimate claim. Oftentimes, if they will do just that, and the personal rep will line it up and try to make a deal with
Okay.
that creditor. If they don't surface after they're served with an objection to the claim, after 30 days, they're barred from making a claim against it. So the personal rep, to answer your question, can protect the estate by doing its due diligence, demanding proof of the debt, and then either taking care of it, you protect the estate that way, or objecting to it.
Is there a period of time for the creditor to come after the estate? And
So-
what is that?
So in the probate process, there's something called a notice to creditors that goes out, where the part of your responsibility is to notify creditors if you know of them. And in general, for the public, they actually put an ad in the paper with the notice to creditors,
Okay.
local business papers. And
There's still newspapers around?
There are.
Oh, wow.
I still read them.
I do too. I can't say I don't.
The
So
creditor
they put
has
a notice to creditors or notice?
Yes.
Okay.
Notice to creditors. The creditor, if they get notice, either through the notice to creditor or directly from a personal rep, has 90 days to surface and file its claim or it's barred.
So if the personal representative goes through the mail and they see a credit card from Citibank, the personal representative then sends a notice to that creditor. And if Citibank doesn't respond within 90 days, is that what you said?
Citibank will be out of luck.
Okay. So they have to do their due diligence as well.
So those are important steps. And an attorney guiding you through the probate will make sure you take care of that kind of notice.
And then is there, I know for personal injury, you have like a 2-year statute of limitations to file a lawsuit after a car accident. Is there a statute of limitations for a creditor to come after the estate?
So after that notice of creditors,
after the notice of creditors,
that's their statute. They don't have the ability to go after the estate after those 90 days.
Okay, but that's for known creditors. What about unknown creditors?
The unknown creditors will not. Again, that notice of creditor generally with the ad in the paper takes care of unknown creditors.
Okay.
Assuming that there was truly unknown.
Right. Yeah.
And they can show, if they show that the personal rep sort of wink, tried to pretend not to know, they have a problem.
Right.
They can surface despite the notice of creditors.
But I mean, there's a lot of times creditors pop out of the blue that nobody ever knew about. And all of a sudden they say, hey, you owed this bill from 4 years ago or something like that.
Yeah. And then the only way the law can address that is through this public process and the ad in the paper.
Okay. That sounds very helpful. Again, it's Tony Demonakis. He is a probate attorney here in Clearwater. He serves all throughout Clearwater and Tampa Bay. I know that. But if you have questions regarding probate or wills and trust, give us a call at 441-3000. We are here live until 6 o'clock, and so this is the time to give us a call. But I also wanted to talk about, challenges or disputes through the probate process. Does the personal representative automatically get appointed, or can somebody challenge the will or challenge the personal representative? What challenges can be done in the probate process?
So we'll start with the will. To challenge a will is very difficult in Florida, but not impossible. The basis for challenging a will are, one, that it wasn't executed properly. So if you don't follow the ritual that we described earlier, presence of 2 witnesses and a notary, the testator, the person who makes the will, didn't understand what he or she was signing, or didn't have the mental capacity to understand and formulate the will. Those are the reasons that wills can get challenged.
Okay.
Legal capacity, mistake, or defect in actual signing. And I've seen wills where witnesses forget to sign, or they're not notarized, and they're just defective.
And I'd seen situations or heard situations where somebody just wrote out their will. They're sick and they write out their last will and testament. They write it all out, and they think it's valid, but they didn't have the formal requirements of a valid Florida will. Does that have any impact on the probate process?
So some people might try to propose, advocate for that, but technically it's not a valid will.
Yeah,
and it's too late.
And that's why it's so important, not just after somebody passes away, but even when you're doing your estate planning, is that you talk to an attorney like Tony that understands what needs to be done to protect yourself now and to protect yourself and your estate and your beneficiaries later. It's so important. I see too many people try to do it on their own, and they turn to Google Esquire to try to do their own estate planning, and you're just asking for problems, I think. Do you agree with that?
I agree. And, even if you go to one of the web-based document generating apps, you're not getting any legal advice. You're not getting any insight as to the process and what you're setting yourself up for. So I strongly recommend when you do estate planning to get legal counsel.
Right. Estate planning, that's the most important part. The planning part is the most important part. All right. This is Matthew Noyes. I am one of the partners at the Perenich, Caulfield, Avril, and Noyes law firm who proudly puts on FLA Law on the radio. We're going to take a commercial break right now, but on the flip side, Tony and I will be here to answer any questions you have regarding probate, wills and trust, or personal injury. We'll be back in just a few.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Perenich, Caulfield, Avril, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Perenich, Caulfield, Avril, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
As promised, we are back. This is FLA Law on the radio. My name is Matthew Noyes, and I'm with the law firm of Perenich, Caulfield, Avril, and Noyes, the longest established personal injury law firm in Tampa Bay. Guy Perenich started our firm in 1955, and ever since then, almost 70 years later, we are still here trying to help people fight insurance companies, trying to be the voice of the injured in the legal system that sometimes doesn't listen to them. So if you have any questions regarding personal injury, give us a call on the law line at 441-3000. But I also have a very fine guest, Tony Damanakis, here as well. And he is here to answer questions that you have regarding business law, real estate, probate, wills and trust, the probate process, and all that. So give us a call at 441-3000 or jump on the live drew a blank. Our live show on Perenich, Caulfield, Avril, and Noyes Injury Lawyers on Facebook, and the live stream. That's the word I was trying to think of. I'm already on my brain to go to the Rays game after this. But go jump on our live stream and type in your question there, and we'll be happy to answer any questions that you have. But Tony, during the first part of the show, you were very informative on the process of, probate and the wills and the trusts and such like that. But I also want to talk about, we were talking about estate planning and how important the planning part of your job really is for your clients. What steps can be taken to minimize family disputes during probate process? And, unfortunately, you see the ugly come out and family disputes in your area of law.
Yeah, it can be really tragic that without proper planning, unwittingly parents can set up future disputes or misunderstandings with their family and their kids. So lots of things can be done. An example that comes to mind is a living will. So this is a document that came, we may recall the famous Terry Schiavo case.
Yeah.
And Terry was tragically brain injured and didn't come out of it. and there was no medical way she could come out of it. And she was in that form, being kept alive by machines for over close to 10 years.
Wow. Yeah, I remember.
And there was a conflict that arose between the husband and the parents. And had she had a living will, it would have made that conflict a lot easier, although the parents challenged it anyway, and the law came out and said, well, at the end of the day, the legal spouse has the right to make the call. And Judge Greer was a very brave judge who upheld the law there. And
Right.
But what I tell parents of kids is to avoid the scenario where, let's say you have 3 kids and mom or dad are in the situation where there's a medical certainty that they're not coming out, but there's a machine keeping them around. If you set forth your wishes, it makes that conversation somewhat easier
For the kids.
for the kids.
Right.
They can know if they're confused about what to do,
Feel guilty.
or 2 out of 3 feel one way and another feels the other way. That living will can speak volumes.
And so the living will is different than the will we were talking about
Exactly.
before.
That's a common misunderstanding. So a living will actually say 3 specific medical conditions: persistent vegetative state. They are, and 2 others, which I'm not recalling right now, but they're specific medical diagnoses. It's not a situation where no matter what, they're going to unplug the
Right.
machine. These are specific brain ailments that are 100% guaranteed you're not coming out.
Right.
Then you say, I either want to be kept alive with a machine and or I want to let my body and nature take its course. So you can say something like that. To avoid conflicts, you can say specifically who gets what. So if there's a valuable Corvette and you want Johnny to get it, say that.
Do you have to give reasons in your will?
No.
No. Okay.
You're also not obliged to give anybody anything.
Okay.
So we have instances where parents choose, for whatever reason, to not give certain kids or any kids anything. They're not obliged legally to do that.
Okay.
The only person who's entitled is a spouse.
Okay. You
Right.
read my next question. I was going to ask you that question.
A spouse cannot be left in the cold, and a minor child cannot be left in the cold
Okay.
with regard to homestead protections.
All right. Talk to us about the surviving spouse. How are they protected under the probate code, the Florida probate code?
So the classic example is, it's something called, the classic example we learn in law school is husband decides to leave everything to the mistress and leaves the wife nothing in his will.
Right.
The wife can break that will with her right to what's called a marital share.
Okay.
So that's basically a minimum share of no matter what the husband might write in the will, the wife has, and this is vice versa. So the wife can write whatever she wants in the will, but the husband will have a minimum share. It's called the marital share that no will can violate as a matter of public policy.
All right.
Homestead, if there's a spouse and a minor child, you can't leave this homestead somewhere else. It's got the wife and the minor child will have a right to live there.
What if there's not a minor child? What in the homestead? Is that part of the elective share, the marital share?
If is in the will and the will tried to leave the spouse out, yes,
Okay.
the wife will have a claim on that homestead.
What about in situations where it's not always intentional? It could be an error that the spouse left the house to their children, but didn't include the surviving spouse.
Surviving spouse has homestead rights.
Okay.
Yeah.
So that's important. Yeah.
That's why you see banks will never give a mortgage, even if, let's say, you're the only one on title to homestead. They will not give you a loan or a mortgage unless the wife signs off, because they have homestead rights. The bank would not be able to foreclose unless they sign the mortgage as well. So homestead's a very great,
It's good protection.
wonderful.
Yeah, it's
And
good protection for the spouse. That's for sure. Nowadays, there's so many blended families, not just in Florida, but all over the country. Is there any protection for blended, or any specific considerations that need to be given when we're talking about blended family, stepchildren, and such like that when you're doing an estate planning?
That's a great question, because oftentimes you'll have people with second marriages, married 30, 40 years, and their kids from prior marriages.
Yeah.
They need to be accounted for in the respective wills. If you just allow everything to go to the surviving spouse estate, the kids from your prior marriage may not be protected unless you specifically say so.
Okay.
So you need to devise a system of who gets what upon the passing of the second spouse. And oftentimes that needs a little discussion between the couple. They need to think it through. And sometimes it can be awkward.
Yeah, I could imagine those conversations.
Yeah, you build a life 40 years together and everything you have is together. But if you die first, you want to be sure that your kids from another marriage get something.
That may not get along with the step parent.
Yeah.
That you still want to have that protection. That kind of puts you kind of in an ethical dilemma. And isn't there sometimes that you may have to separate the two parents when you're talking about estate planning to discuss each other's wishes?
Yeah. You always give them the understanding that they are free actors and they must do whatever they're comfortable doing. So I won't go ahead and finish a plan if I feel someone's under duress.
Okay.
Just won't do it. People come in dragging along a spouse or a friend and say, John, my husband John wants a will, and John doesn't know what day of the week it is. I'm not going to do it.
Yeah, and he wants to leave it all to me or something like that.
It happens all the time.
Really? Yeah. Wow. I thought that was just on TV. But now it happens all the time.
One tool that I wanted to mention about, we haven't touched upon yet, is something called a power of attorney. This is a document that'll let you do, you will give someone the power to whatever you do with a pen, I can do with a pen in your name.
Okay.
Very powerful document. You should not give it to anyone who you don't trust 100%. The reason I bring that up is people can misuse the power of attorney. So they'll come in, try to change a will using a power of attorney. Can't do it.
Okay.
They'll come in, trying to change properties and ownership, trying to sell things when grandma goes into dementia. Grandma needs a house to live in.
Right.
They'll try to sell the house and put grandma in a nursing home. You see all kinds of things.
And the durable power of attorney doesn't allow them to do that?
So in theory, the durable power of attorney would allow
that's what I was afraid
principal
of. Yeah.
to do that, right? So back to the estate plan. What you do is you can give yourself a life estate in the property. I had a case where it was clear to me that grandma was always took care of her family. 16 or so grandkids from prior marriage, all kinds of things going on. Toward the end, she lost her husband. Grandma started to go into dementia and a little forgetful, but still sharp as a tack. But she started giving generous gifts. And my concern was, well, Grandma, you're spending down what you have for your good old days, for the final days. She wasn't worried about it. She was in her 80s. She wanted to help the kids. Things go quiet for a couple of years. All of a sudden, you get a call from the so-called power of attorney, whose grandma wanted to be sure that her one son had protection because he had some issues, and he would always, regardless of her giving away the money, this one son would have a place to live.
Okay.
So she gave him a life estate. And sure enough, you get the call from the power A. Oh, we're selling grandma's house. She needs a home. I said, well, that wasn't grandma's wishes. Grandma wants her son A to always have a place to live. So you can't sell that.
Wow.
So there's so many complex things that can come into play, unanticipated. But when you do that plan, you can come close to making sure things get done. So her her one son will have a place like she always wanted.
Oh, that's wonderful.
And the kids spent every other cent that she had.
Yeah. Well, and again, that's the planning part of estate planning. And the durable power of attorney is one of those ways to plan. Now, as we kind of just talked about, the durable power of attorney is very beneficial because it can aid somebody if they. Let me ask you this: can the durable power of attorney assist when the person loses capacity, mental capacity?
Probably the most important function is you don't need to get a guardian appointed if you have a POA.
Okay.
So God forbid you had a bad accident or a stroke and you lose your capacity to pay your bills. The POA can do that for you.
Okay.
POA can contact agencies, banks.
So they can stand in the shoes for you if you lose capacity, whether for a short period of time or a long period of time.
Right.
How long does that durable power of attorney last?
It lasts till you die.
Okay. And the day that you die is...
It's done.
Okay.
Yeah, then you go into the probate process.
Okay.
But the durable power of attorneys are not effective after death.
Okay. But that's a very powerful and important estate planning tool to use.
It's so powerful that when I do one for a client, I actually make them sign a letter. It's called a CYA letter, cover your...
You know what? Yeah.
And I said, I've advised you that this is a very powerful document, that you should not give it out unless you completely have confidence in the person you're giving this power to. Even if it's a husband and wife, I make them sign that letter.
That's a good idea. You keep it in a safe deposit box or something. Yeah. No, I think that's good. But let's talk about, we kind of talked about how parents can protect their minor children through the estate planning. You can set up a trust or that testamentary trust. Is that
so? It's a trust that comes out of the will. So the will say, if I die and Johnny and Susie are under 18 or under 25 or under 35, depending on what the circumstances are, that you create, I want this person to be trustee. I want you to hold the money in trust for them. Then you have flexibility. You could say, just hold it and invest it until they get to 25, or give them $2,000 a month until they get to 25. Along the way, if they need to go for higher education or medical expenses, books and the like, or housing, you can give the trustee discretion, that they have discretion to use the money for a good reason, for the benefit of the children. So that's how you manage the money even if you die.
That sounds good. But you can do that in the living trust as well and avoid the probate, the cost of that as well.
Exactly.
All right, that's good. What happens if the estate plan changes? There's a significant asset that comes into play. Let's talk about both. Let's talk about the trust. If you have a trust and you buy a second home, does that second home go into the trust, and how does that happen?
So if you want it to go in the trust, you can actually just put it in the trust at closing.
Okay.
So you can tell the title company when you're buying that instead of putting it in the name of Matthew and Tony, we're going to put it in the Matthew and Tony Irrevocable Trust, dated whatever date you created it. And it's literally deeded right into the trust. And it's in there. So it's simple. If you get an inheritance from somewhere and you put it in a bank account, you can tell the bank, I want this account in my trust. And they will title it in the trust.
Okay.
If you forget something, or
I was going to ask you that. What if you have this trust, but you forget to put an asset or that automobile that we talked about, because you don't want to put that in a trust because of the dangerous instrumentality doctrine, which is a whole nother story all in itself. But if you have an asset that's outside of the trust and you pass away, what happens to that asset?
So when we do a trust, we also create a will, and we call it a pour-over will.
Okay.
And essentially the will say, if there's something out there I forgot, pour it into the trust. So if it's dangling in your name alone, it will go into the trust, and then the trust will be distributed as you instruct.
Okay.
And then we also add to the pour-over will, well, for some reason you can't find my trust, or it's invalid for any reason, do what I said should be done in the trust. And I'll literally just reiterate what the trust said.
Oh, I never knew that part of the pour over will. That's interesting.
It's just an overly precautious way of making sure your wishes are done.
That's great. Yeah, that's a great way to do it. What's your recommendations when life events occur, marriages, divorces, and such like that, when it comes to estate planning? How about a divorce? Let's talk about a divorce. What if you have a will and you have your spouse listed as receiving all the assets, but then you divorce and you pass away before you change the will? What happens? Does the ex-spouse get all the assets?
So it's a great question. Upon a life event such as a divorce, you should totally update your estate plan. I'll give you an example. Young couple, 2 minor children, 3 minor children, divorce. If following the divorce, there's no will, it'll go to their kids, but guess who's managing it for their minor children? The ex-spouse.
Oh, okay.
So guess who controls those funds? The ex-spouse.
Oh, okay.
So despite the divorce, the ex-spouse still will control what you leave behind. So you can create a will or a trust that says, God forbid I pass, I want someone else to be the trustee for the benefit of my kids.
Okay.
Right? But that doesn't leave it to the ex-spouse.
Right.
So, which may or may not be a good thing. We would hope that the ex-spouse would care for the children and do the right thing. But given the context of the divorce, maybe that's not the case.
Yeah. But does the ex-spouse get anything, even if they are listed as the surviving spouse in the will?
No. Florida law under the divorce severs that, by virtue of the divorce, severs that bequest under the will.
All right.
But they would get it indirectly, perhaps, by being able to control it for the minor children.
Yeah,
so that's a pitfall.
So you do got to really be careful in any of these major life events. Having a child, it's important as well, right?
Right. If you did a will and there's no child mentioned, you certainly want to update that situation to reflect that your kids, even if you can say one child, for example, and provide in the will that if more come, it'll be equal shares.
Okay.
Right. Or a common example is parents take care of certain kids during their lives because they needed a house, lent them the money for whatever reason. You can adjust the estate plan to rectify the imbalance if that's something you were interested in doing. So suppose I gave my one kid $500,000 during their life, and I know that I'm going to die with a limited amount of funds. You can say, this kid doesn't get as much as he would have gotten because I've previously provided.
Oh, that makes sense.
And you say it, or
again, put that into the will or into the trust to make sure that happens.
And it's what you asked about earlier. How do you avoid problems? And that's exactly how you avoid it. Being clear, and setting forth, why you're doing what you're doing.
Now, we talked about if it's a divorce, the family law statute says that it severs that part of the will. What if they never officially divorced, but they were legally separated for years and years and years, and you just never bothered getting a divorce, but they also never bothered changing the will?
What happens? Huge mess.
I can imagine.
As they're not divorced, they're technically married.
Yeah.
Whether you're separate or not. Florida doesn't have legal separation. So if you're not divorced, you're married. And if you're married, you have rights. So if you don't want those rights to carry along in the untimely death, you need to do a proper plan.
That it's so important. Any life event, it's so important to do that planning in order to make sure that when you're not there, your family's not suffering even further. Despite your loss, they have to suffer even further for the mess that you left them in essence. Yeah. So I know we used to do FLA law live on television many, many years ago on cable TV. and we used to do live call-in TV show. And we took a poll, and the most asked question I think we did that for 10 years. The most asked question in the 10 years that we did FLA Law on TV was, what if I have a will in New York and I move down to Florida? Is my will in New York still valid in Florida?
Wonderful question.
Yeah, and that asked a lot because our snowbirds and people that move down. What do you tell our listeners that answer to that question? Because I'm sure our listeners are asking that same question based on how many times it was asked when we had the television show.
So the state of Florida will honor your will from another state, provided that the will was done validly and legally in that state. So as long as it was a valid New York will, it will be recognized in the state of Florida.
Okay. But you run the risk of that being disputed or fought about if, let's say, New York says you only need one witness and Florida says you need two. Then you could have to fight that battle, which could easily have been fixed by just rewriting the will under Florida's law. Is that right?
There are always clever ways to challenge something. And yes, you can avoid it by updating. It's always a good idea. I recommend to clients every 5 years or so, dust off your estate plan, place a call to your lawyer, say, do I need to worry about any new laws or new changes or any tax laws? 5 years, 10 years the most. Just look at it for 5 minutes. Make sure everything's in order.
I think that's great information because you forget about it and you don't remember what life events happened because they're significant life events. You're worrying about those things.
Yeah.
So it's very important that you do update your estate plan. At least talk to the attorney.
So you touched upon a New York or another state. Well, we have a lot of folks here, obviously from New York, New Jersey, Illinois, Ohio.
Yeah, I know. I was at the Cincinnati Reds versus Rays game, and there was all kinds of Cincinnati Reds fans there. So a lot from Ohio.
Many folks, snowbirds, have primary estate up north and a home here, or vice versa, right? Will you have to probate in 2 states? The general answer is yes, if you don't have a trust.
Okay, so you have to do probate. If you had property up in New York, you would have to have Florida probate and a New York probate.
Right.
I knew that answer because you helped a friend of mine that had that situation. So, Tony, we're wrapping it up. How can our listeners get in touch with you when you're not here on the radio?
First of all, thank you, Matthew, for a wonderful opportunity. And you have a great firm, and I always refer personal injury matters to you in disability cases, and I have full trust and confidence in your firm. We're at Sunset Point Road in Clearwater, 2348 Sunset Point Road. My phone number is 727-796-7774. Happy to speak to you anytime.
Thank you, Tony. Thank you for coming. And as I always end the shows, I encourage you to drive safely and watch out for those who don't. We'll talk to you next week. Good night.
WTAN, Clearwater,
FM 106.1,
WDCF, Dade City,
FM 102.3.
Listen.
This is CBS News on the Hour, sponsored